Your trees are out of compliance with community canopy management standards. You have 14 days to authorize removal, or the association will proceed on your behalf." She said it the way someone reads from a script they have memorized, but never questioned. Standing at the edge of my gravel drive in a blazer too clean for the dust out here, holding a clipboard like it was a gavel. Behind her, a white SUV sat idling on the county road, engine running, as if she expected to be gone in under 3 minutes. I looked at her. Then I looked past her, up the long rise of the property, to where 200 heritage oaks stood in the morning light. Trees my grandfather Elias Calloway had walked through as a young man, trees that had been on this land since before the county itself was incorporated. I did not say anything for a moment. What she did not know, what she could not have known because she had apparently never looked at a plat map or a deed in her life, was that every inch of ground she was standing on, every root those trees had ever sent into the earth, was mine, recorded, surveyed, titled. A deed in a fireproof drawer in my study, as clear as anything the county recorder had ever stamped. Drop a comment and tell me where you're from, and if something like this has ever happened to you, I want to hear it. I told her I would look into it. She left, and I went inside and opened the drawer. My name is Robert Calloway. I am 61 years old, and I have lived on this land for all but 9 of those years. The 9 I spent studying civil engineering at the State University, learning the language of surveys and load-bearing structures and legal descriptions, which turned out to be exactly the education this property would one day require of me. I came back because my father asked me to, and because the land itself had a kind of gravity I had never found anywhere else. There is a smell to this place in early morning before the dew burns off, something between creek water and cedar bark and the particular dark richness of soil that has never been broken by a plow. My grandfather Elias knew that smell. My father knew it. I knew it the way I knew my own name. Elias Calloway acquired this property in 1941, 340 acres in the hill country of central Texas, purchased outright with money he had saved across 12 years of working a sawmill and a small cattle operation. He did not inherit it. He earned it, dollar by dollar, in the way that men of his generation earned things, quietly, without announcement, with a patience that looked from the outside like stubbornness. The deed was recorded at the county courthouse on March 14, 1941, and it named Elias James Calloway as sole owner of the parcel described in Exhibit A, which ran to the creek on the south, the old limestone ridge on the north, and included every tree, every rock, every acre of what would eventually become known as the Calloway property. He planted some of those oaks himself, not all of them. The oldest ones were already there, their trunks wider than a man's arm span, their roots sunk so deep into the caliche that they had survived droughts that killed everything around them. But Elias planted the ones along the eastern fence line in the spring of 1943, saplings grown from acorns in coffee cans on the back porch of the original house. He planted them 30 feet apart because he said he wanted his grandchildren to walk in shade. I walked in that shade as a boy. My own children walked in it. 200 trees, give or take, spread across the eastern and southern portions of the property, some of them now 4 feet in diameter, their canopies interlocked overhead like the vaulting of a cathedral. My father, Thomas Calloway, kept the property intact through a period when a great many families in the county were selling off parcels to developers. The hill country was changing in the 1970s and 1980s. Subdivisions were appearing where cattle had grazed. My father watched all of it from the front porch and did not sell a single acre. When he transferred the property to me in 2004, the deed was updated and recorded, still 340 acres still whole. I paid the property taxes every year, maintained the fences, managed the land with the help of a part-time ranch hand named Darnell, who had worked for my father before me. The land simply was, as it had always been, and I cared for it the way you care for something that is not replaceable. The Ridgeline Estates HOA had been incorporated in 2011. A developer named Hargrove had purchased 80 acres adjacent to my southern boundary, land that had once belonged to a family named Pruitt, sold off in pieces after the patriarch died without a clear succession plan. Hargrove built 140 homes on those 80 acres, put in a community center and a pool, and established covenants governing everything from fence height to mailbox color. The HOA was formed to administer those covenants. That was its legal purpose, to govern the 80 acres of ridgeline estates, nothing more and nothing less. My property line ran along their northern boundary. We were neighbors in the loosest sense. I could see their roof lines from the limestone ridge on a clear day, but I had no particular relationship with the community and no reason to. Our properties were separate. The line between them was surveyed and recorded. I had a copy of the survey in the same fireproof drawer as the deed. The woman with the clipboard was named Sandra Pruitt. She was the president of the Ridgeline Estates HOA board, elected the previous spring, and she had apparently come into her position with ideas about the association's authority that were not well tethered to its actual legal foundation. I learned this gradually in the weeks after her first visit as the certified letters began to arrive. The first letter came 8 days after she stood in my driveway. It was printed on HOA letterhead, signed by Sandra Pruitt as board president, and it cited Section 12.4 of the Ridgeline Estates Community Standards, a document I had never agreed to, never signed, and had no legal obligation to observe. Section 12.4 addressed canopy management within the community's shared natural buffer zone. The letter asserted that my tree line constituted part of this buffer zone, and that the oaks were therefore subject to HOA standards requiring removal of any tree deemed to pose a sightline obstruction, a fire hazard, or an aesthetic inconsistency with community character. The fine for noncompliance was listed as $500 per week. I read that letter 3 times. Not because it was complicated, it was not, but because I wanted to be certain I understood exactly what was being claimed. Sandra Pruitt and the Ridgeline Estates HOA were asserting authority over trees that stood on land I owned outright, under a covenant document that had never been recorded against my property, citing a buffer zone that did not appear on any plat map or recorded easement I had ever seen. I did not respond immediately. I filed it in a manila folder labeled simply Ridgeline, placed that folder in the filing cabinet next to the drawer that held the deed, and called my attorney. His name was Gerald Marsh, and he had been practicing property law in this county for 31 years. He was not a dramatic man. He spoke slowly and chose his words with the care of someone who had learned, over 3 decades, that precision was the only currency that held value in a courtroom. I faxed him the letter that afternoon. He still used a fax machine, which I had always found reassuring, and he called me back the following morning. "Robert," he said, "do you have a copy of the Ridgeline Estates plat and their recorded covenants?" I told him I did not, but that I could get them. "Get them," he said, "and pull your own survey while you're at it. I want to look at where they think this buffer zone is." I drove to the county recorder's office the next morning. The clerk, a woman named Patrice who had worked there for as long as anyone could remember, pulled the Ridgeline Estates plat without difficulty. It was a standard subdivision plat recorded in 2012, showing the 80-acre parcel, the lot lines, the streets, and the boundary of the development. The northern boundary of Ridgeline Estates was marked clearly. It ran along a line that corresponded exactly to the southern boundary of my property as described in my own deed and survey. There was no buffer zone on the plat. There was no easement running north into my property. There was no recorded instrument of any kind that extended the HOA's authority beyond the 80 acres it was formed to govern. I stood at the counter and looked at that plat for a long moment. Patrice watched me with the mild patience of someone who had seen many people have realizations at her counter. I asked for certified copies of the full plat, the recorded covenants, and my own deed and survey. She had them ready in 20 minutes. Gerald reviewed everything over the following week. His assessment was precise. The Ridgeline Estates HOA had no recorded easement, no covenant running with the land, and no legal instrument of any kind that established jurisdiction over my property or the trees that stood on it. The buffer zone referenced in Sandra Pruitt's letter was not a legal designation. It was language from the HOA's own internal community standards document. A document that governed only the properties within Ridgeline Estates, whose owners had signed it when they purchased their homes. I had signed nothing. My land was not within Ridgeline Estates. The claim had no legal foundation. Gerald recommended a formal response letter, sent certified mail, notifying the HOA that their claimed authority over my property was without legal basis, and that any further action taken against my trees or my land would be considered trespass. I told him to send it. He did on a Thursday, and I kept the return receipt when it came back signed. Sandra Pruitt's response arrived 10 days later. It cited several additional sections of the Community Standards document, along with a reference to what she called long-standing community practice regarding the buffer zone. There was no new legal instrument. There was no recorded easement she had somehow located in the interim. There was only more assertion, more confidence that the weight of her title and her letterhead would accomplish what the law had not given her. I was not angry. I want to be clear about that. What I felt, reading that second letter, was something closer to a quiet attentiveness. The same feeling I get when a load-bearing calculation comes back with a number that doesn't match the structure in front of me. Something is wrong, and the wrongness is informative. I added the letter to the Ridgeline folder and called Gerald. "She's not going to stop," I told him. "No," he said. "She's not. So let's make sure we're ready when she doesn't." The morning I found the stumps, the air smelled of cut wood and something sharper underneath it, chainsaw exhaust, still hanging in the cold. The particular resinous grief of old oak opened to the sky. I walked the eastern fence line in the early light and counted. I counted the stumps the way you count something you do not want to believe. 43 along the fence line, 19 more on the southern slope. The crews had worked through 2 days while I was in Austin for a family matter, and they had taken down trees that had stood on this land since before my grandfather was born. 206 trees, as the arborist would later confirm. The largest had a trunk diameter of 51 inches. It had been alive for approximately 240 years. I stood at the edge of what had been a canopy and was now open sky, and I did not speak. There was nothing to say to the stumps. There was only the work of what came next. I called Gerald from the fence line. He answered on the second ring. I told him what I was looking at. He was quiet for a moment, then said, "Don't touch anything. I'm calling an arborist and a photographer this morning." I walked back to the house, made a pot of coffee, and sat at the kitchen table with the Ridgeline folder open in front of me. The folder was thicker now. It held Sandra Pruitt's 2 letters, Gerald's response, the certified mail receipts, the county plat, the recorded covenants, my deed, my survey, and a set of weekly photographs I had taken of the tree line over the previous 2 months, dated, showing the trees standing intact. I had started taking them the week after the first certified letter arrived on Gerald's advice. I had not known at the time exactly what I was documenting. I knew now. The arborist Gerald sent was a man named Dr. Philip Okafor, a certified arborist and forensic tree consultant who had testified in timber trespass cases across the state. He arrived 2 days after the cutting, walked the property with a measuring tape and a camera and a notebook, and spent 4 hours documenting every stump. His report, which arrived 3 weeks later, was 72 pages. It identified 206 removed trees, classified by species, age, and diameter, and estimated their value under Texas Natural Resources Law, which provides for recovery of stumpage value plus damages. It also noted that the trees removed were consistent with the classification of heritage oaks, which carries specific legal weight under County Ordinance 14-87, requiring a permit for removal of any oak with a trunk diameter exceeding 8 inches at breast height. No permit had been issued. Gerald confirmed this with a single phone call to the county arborist's office. Between Gerald's response letter and the arborist's report, I had done something that might have looked from the outside like patience. It was not patience exactly. It was the deliberate stillness that comes from understanding that every action taken in haste becomes a liability, and every action taken in order becomes evidence. I had been building a file the way my grandfather built fence lines, post by post, each one set plumb, each one tamped firm before moving to the next. What I had not yet done was look carefully enough at the boundary. That sounds like a simple thing. In property law, it is never a simple thing. A boundary is not a line on the ground. It is a legal description, a chain of title that runs backward through every conveyance since the original patent. My survey was current, commissioned in 2006. But a survey is only as good as the monuments it references, and monuments shift. Caliche erodes, iron pins rust and sink. Fence lines drift over decades as ranchers rebuild posts in slightly different places, and the drift accumulates until a fence that was once on a line is a foot off it, or 10 feet or more. I had lived on this land for 52 years and had never had cause to question where my southern boundary sat, until now. It was my neighbor to the east, a man named Calvin Treadwell, who first planted the question. Calvin had been ranching the adjacent property for 40 years, and he had the particular quality of attention that comes from spending a lifetime reading landscape. He stopped by one afternoon while I was walking the fence line with a measuring tape. "You know," he said at last, "when Hargrove's crew put in those subdivision roads, they ran a survey of their own. I always thought their stakes were a little north of where the old Pruitt line used to be." He looked at me, steady and unhurried, the way men of his generation looked at things they had been thinking about for a while. "Might be worth pulling the original Pruitt survey," he said, "the one from before the sale." I thanked him. I drove to the county recorder's office the following morning. Patrice remembered me, or perhaps she simply remembered the kind of person who comes in asking for old surveys. I asked for the original Pruitt survey, the one conducted on the parcel that had eventually become Ridgeline Estates prior to the Hargrove sale. She searched the index twice, went into the back room, and was gone for 20 minutes. When she returned, she was carrying a rolled document in a cardboard tube, the kind that holds something old enough to have been stored rather than filed. "This is the 1978 survey," she said, "most recent one before the Hargrove sale." I unrolled it at the counter. It was a large format drawing, hand-drafted in the style of the period, with boundary lines inked in black and dimensions noted in a careful surveyor's hand. The northern boundary of the Pruitt parcel was described as commencing at an iron pin at a specific coordinate and running east along a bearing of north 89 degrees, 14 minutes, 42 seconds east for a distance of 2,847.3 feet to a second iron pin. I wrote that description in my notebook, asked Patrice for a certified copy, and drove home. That evening, I spread the 1978 Pruitt survey and my own 2006 survey side by side on the kitchen table, under the lamp that had sat there since my father's time. The two surveys agreed. The line between my property and the former Pruitt parcel was unambiguous, and it had not moved. Then I pulled the Ridgeline Estates plat from 2012 and laid it alongside the other two. The northern boundary of Ridgeline Estates, as shown on the 2012 plat, did not match the 1978 Pruitt survey. The discrepancy was consistent. The 2012 plat showed the northern boundary running approximately 38 feet north of where the 1978 survey placed the Pruitt parcel's northern edge. 38 feet, running the full length of the boundary, which meant that a strip of land, roughly 38 feet wide and 2,847 feet long, land that was described in my deed and survey as belonging to me, was shown on the Ridgeline Estates plat as falling within the development's boundary. I sat with that for a long time. The lamp hummed. Outside, the creek made its low sound in the dark. I called Gerald the next morning. He was quiet for longer than usual. "Send me the surveys," he said. "All three, and your deed. I want a licensed surveyor on the ground, boots on the ground, new monuments, GPS coordinates. I want to know exactly where your pins are, and exactly where Hargrove's plat says they should be." The surveyor Gerald recommended was a man named Thomas Vickers, a licensed state land surveyor with 30 years of experience in boundary disputes. He arrived on a Tuesday morning with a crew of 2 and equipment that included a total station and a GPS receiver accurate to within a centimeter. They spent 2 full days on the property, locating the original iron pins, cross-referencing them against the county's geodetic control network, and running the boundary line in both directions from each monument. I stayed out of their way. I brought them coffee in the morning and left them to their work. Vickers's report arrived 10 days later, 44 pages with survey drawings, coordinate tables, and a narrative section written in the careful, qualified language of a professional who understood that his words might one day be read aloud in a courtroom. His findings were not equivocal. The original iron pins placed by the 1978 Pruitt survey were located and verified. They corresponded precisely to the boundary described in my deed. The 2012 Ridgeline Estates plat had placed the northern boundary of the development 36 feet, 9 inches north of those pins, a discrepancy Vickers described as inconsistent with surveying error and consistent with a deliberate northward shift of the boundary line at the time the subdivision plat was drafted. 36 feet, 9 inches, on a parcel running nearly 2,847 feet along its length. That strip amounted to approximately 2.4 acres. And it was on that strip, that narrow ribbon of ground that Hargrove's plat had quietly absorbed, that the eastern fence line stood. The fence line where Elias Calloway had planted saplings from coffee cans in the spring of 1943. The fence line where, over the previous 2 months, Sandra Pruitt's hired crews had cut down 206 heritage oaks. Every tree they had taken was on land that the Ridgeline Estates plat claimed as part of its northern boundary. Every tree they had taken was on land that my deed, my survey, and now Thomas Vickers's independent field survey confirmed as mine. I sat with that knowledge the way you sit with something that has weight. Not anger, not satisfaction, not yet. Something more like the feeling of a structure settling into its foundation. The quiet recognition that the load had found its bearing point and that everything which came next would rest on what I had just confirmed. I added Vickers's report to the Ridgeline folder, which had grown substantial enough that I had moved its contents into a tabbed binder organized chronologically. Sandra Pruitt's first letter, her second letter, Gerald's response, the certified mail receipts, the 1978 Pruitt survey, the 2012 Ridgeline plat, my deed, my 2006 survey, Dr. Okafor's arborist report, Vickers's boundary survey, each document cross-referenced to the next. Each one a link in a chain that ran from my grandfather's name on a deed recorded in 1941 to a strip of ground where 206 stumps now stood in the morning light. Gerald filed the lawsuit on a Friday. The caption read Calloway versus Ridgeline Estates Homeowners Association et al., and the causes of action were timber trespass under Texas Natural Resources Code Section 151.001, trespass to real property, conversion of timber, and violation of County Ordinance 14-87 governing the removal of heritage oaks without a permit. The defendants named were the Ridgeline Estates HOA, Sandra Pruitt in her individual capacity as board president, and Hargrove Development LLC, whose 2012 plat had provided the false boundary Sandra Pruitt had apparently relied upon when she sent her crews onto land she did not own. The complaint was 41 pages. Gerald had attached Vickers's survey, Okafor's arborist report, my deed, the 1978 Pruitt survey, the 2012 Ridgeline plat with the boundary discrepancy annotated in red, and every letter in the Ridgeline binder. He had also attached as Exhibit L the certified mail receipt bearing Sandra Pruitt's signature, proof that she had received his letter explicitly informing her that the HOA had no legal authority over my property and that any action taken against my trees would constitute trespass. She had signed for that letter on a Thursday. Her crews had begun cutting on the following Monday. That sequence of dates was, as Gerald noted in the complaint, significant. It transformed what might otherwise have been characterized as a good faith error into something the court would be asked to consider in a different light entirely. The courtroom in the county seat was not a grand room. It had the particular plainness of a space that has been used for serious work for a long time, wooden benches worn smooth at the edges, fluorescent lights that buzzed faintly when the room was quiet, a judge's bench of dark oak that had been refinished at least once and showed it. The air smelled of old paper, and the staleness of a building sealed against the heat for most of the year. I sat at the plaintiff's table with Gerald on my left and Thomas Vickers's survey rolled in a tube beside the binder. The binder was tabbed and indexed. Gerald had made 3 copies. One for the court, one for opposing counsel, one for our table. He set his copy flat in front of him and did not open it during the preliminary proceedings, because he did not need to. The Ridgeline Estates HOA board occupied the rows directly behind the defense table. Sandra Pruitt sat in the center, flanked by 4 other board members. They had retained an attorney named William Doss, a man from the city who wore a suit that fit him well and carried himself with the confidence of someone accustomed to cases where the other side does not have a Gerald Marsh. Hargrove Development, LLC, had retained separate counsel and had, in the weeks before trial, filed a motion for summary judgment asserting that any boundary discrepancy in the 2012 plat was the result of surveying error and not actionable fraud. The court had denied that motion. The Honorable Margaret Aldine had been a district court judge in this county for 17 years. She was not a theatrical woman. She read briefs carefully and asked questions that were precise and rarely rhetorical. And she had a reputation among attorneys who practiced in her court for a quality Gerald described simply as rigor. She came to the bench at 9 o'clock, settled her reading glasses, and opened the case file without ceremony. The trial took 3 days. Gerald presented the chain of title first, the 1941 deed, the 2004 transfer, the 2006 survey, each document entered into evidence in the order it was created. He called Thomas Vickers, who testified for the better part of a morning about his methodology and findings, and who answered opposing counsel's cross-examination with the calm specificity of a man who had testified in boundary disputes for 30 years. He called Dr. Philip Okafor, who walked the court through his arborist report, identifying each of the 206 removed trees by species, age, and diameter, and who testified that the largest tree removed had been alive for approximately 240 years day, that it had been standing on that ground before the Republic of Texas existed. William Doss objected to that last observation as irrelevant. Judge Aldine overruled him without looking up from her notes. Gerald called me to the stand on the afternoon of the second day. I testified about the property's history, about my grandfather Elias, about the saplings planted in coffee cans in the spring of 1943. I testified about Sandra Pruitt's first visit, about the certified letters, about Gerald's response letter and the certified mail receipt bearing her signature. I testified that I had received that receipt on a specific date and that the cutting had begun 4 days later. Gerald entered the receipt into evidence as Exhibit L. He entered the weekly photographs of the tree line as Exhibits M through AA. He entered the county arborist's confirmation that no removal permit had been issued as Exhibit BB. William Doss cross-examined me for 40 minutes. He asked whether I had ever formally notified the HOA of my property's boundary prior to the cutting. I told him that Gerald's certified letter had done precisely that, and that Sandra Pruitt had signed for it. He asked whether I had made any attempt to communicate directly with the board before filing suit. I told him I had not, and that I had not been required to, and that the record of my attorney's certified letter constituted more than adequate notice. He sat down. I returned to the plaintiff's table. Sandra Pruitt testified on the morning of the third day. She testified that she had relied on the 2012 Ridgeline Estates plat when she determined that the tree line fell within the community's natural buffer zone. She testified that she had understood the buffer zone to be part of the HOA's managed area. She testified that she had acted in good faith. Gerald's cross-examination was brief. He asked whether she had received a certified letter from his office prior to authorizing the removal crews. She said she had. He asked whether that letter had stated in explicit terms that the HOA had no legal authority over the Callaway property and that any action taken against the trees would constitute trespass. She said she had understood the letter to be a dispute of the HOA's position, not a legal determination. Gerald asked whether she had, at any point prior to authorizing the removal, consulted with a licensed attorney about the HOA's legal authority over the Callaway property. She paused before answering. She said no. He thanked her and sat down. Judge Aldine took the case under submission at the close of testimony on the third afternoon. I drove home along the county road and turned in at the gravel drive and sat on the front porch until the light went. The stumps were invisible in the dark, but I knew where they were. I had walked among them enough times that their positions had become a kind of map I carried without trying. Gerald called me 3 weeks later on a Tuesday morning when the ruling landed in his inbox. I drove to his office and sat across from his desk while he read it aloud. The room smelled of coffee and old law books and the particular dry warmth of a space that has been used for serious work for a long time. He read slowly, the way he did everything, and I did not rush him. The ruling was 47 pages. Judge Aldine found, on the evidence, that the northern boundary of the Ridgeline Estates development, as shown on the 2012 plat, was inconsistent with the monuments established by the 1978 Pruitt Survey and confirmed by Thomas Vickers's field survey. She found that the strip of land in question, 36 feet, 9 inches wide, running 2,847 feet along the northern boundary, was the property of Robert James Calloway, as described in the deed recorded March 14, 1941, and updated in the transfer of 2004. She quieted title to that strip in my name. She found that the Ridgeline Estates HOA had committed timber trespass under Texas Natural Resources Code, Section 151.001, trespass to real property and conversion of timber. She found that the removal of 206 heritage oaks without a county permit constituted a violation of County Ordinance 14-87. She found that Sandra Pruitt, in her individual capacity, had authorized the removal after receiving explicit written notice that the action would constitute trespass, and that this sequence, the certified letter received, the cutting authorized 4 days later, precluded any finding of good faith. Then Judge Aldine reached the question of damages. Gerald read that section slowly, and I noticed that he set the pages down between paragraphs in a way he did not usually do, as if he wanted each number to settle before introducing the next. Under Texas Natural Resources Code, Section 151.001, a defendant who commits timber trespass is liable for 3 times the value of the timber taken. Dr. Okafor's report had valued the removed timber, accounting for species, age, diameter, and the specific provisions governing heritage oaks under county ordinance, at $1,412,000. Trebled, that figure became $4,236,000. To that, Judge Aldine added actual damages for trespass to real property, assessed at $280,000. Representing the diminution in value of the property resulting from the removal of the trees. She added attorney's fees under the fee-shifting provision applicable to the ordinance violation. She assessed civil penalties under County Ordinance 14-87 at the maximum rate per tree, a figure that, applied to 206 trees, added another $412,000. The total judgment against the Ridgeline Estates HOA and Sandra Pruitt, jointly and severally, was $5,146,000. Gerald set the papers down. He did not editorialize. He did not need to. The status conference to formally enter the judgment into the record was scheduled for 8 days later. Gerald told me I was not required to attend. I attended anyway because I had been present for every step of the preceding year, and I saw no reason to stop now. The courtroom had the same smell it always did: old paper, sealed air, the faint mineral residue of decades of serious proceedings. I arrived early and took a seat in the gallery, 3 rows back on the plaintiff's side. I set my hands in my lap and I waited. The 5 HOA board members filed in together and arranged themselves along the row directly behind the defense table. Sandra Pruitt took the center position, in a blazer similar to the one she had worn the morning she stood at the end of my gravel drive. Clifford Baines, the HOA treasurer, settled into her left, a heavy-set man who had signed 2 of the certified letters as secretary. The 3 remaining board members, Gary Hendricks, whose name appeared on the HOA's letterhead as a member-at-large, and 2 others whose names I had learned from the governance documents filed as exhibits, filled out the row. William Doss sat at the defense table with a yellow legal pad he had not written on. He did not look toward the gallery. Judge Aldine came to the bench at 9 o'clock precisely. She settled her reading glasses, opened the file, and nodded to the clerk. The clerk read the case caption in the practiced, uninflected voice of a woman who had read many numbers into many records. She read the judgment amount: $5,146,000, jointly and severally, against the Ridgeline Estates Homeowners Association and Sandra Marie Pruitt, individually. The number crossed the room the way a cold front crosses open country, not loudly, but completely, touching everything at once. I was watching the board members when it landed. There was a lag first, the brief interval between hearing a number and understanding what it requires of a person. Then the understanding arrived, and it arrived in each of them differently, and I will tell you what I saw because I think it matters. Sandra Pruitt's face went through a sequence that took perhaps 4 seconds. The color left it the way heat leaves a stone after sundown. Not all at once, but steadily, draining from her cheeks and then from around her mouth until what remained was something pale and very still. Her jaw did not move. Her hands, which had been resting flat on her knees, tightened once, the knuckles whitening briefly, and then went flat again, as if she had decided consciously not to show anything further. She did not show anything further. But what had already crossed her face was enough. Clifford Baines put both palms on the bench in front of him, a sudden, involuntary gesture, as if the floor had shifted slightly beneath his feet, and he needed to confirm it had not. He stared at the surface of the bench for a moment, then looked at William Doss with an expression that was not quite a question and not quite an accusation, but contained elements of both. Doss did not look back at him. Gary Hendricks turned his head sharply toward Doss and held it there, waiting for something, a word, a gesture, any signal that the number could be contested or revised. Doss offered nothing. Hendricks turned back toward the front of the courtroom and sat very still, in the particular stillness of a man who has just grasped the full perimeter of something he cannot walk back from. The 2 remaining board members did not move at all. They sat with the frozen quality of people who are processing information faster than their bodies can respond to it, their faces not blank exactly, but suspended, as if the machinery behind their expressions had paused mid-operation and not yet resumed. William Doss looked at the surface of the defense table. He did not look up. Judge Aldine entered the judgment without comment. She did not address the gallery. She did not address the board. She gathered her papers with the unhurried efficiency of a woman who had other cases waiting, and she left the bench. The whole of it, the reading of the number, the entering of the record, the departure, had taken perhaps 4 minutes. I was not angry, sitting in that gallery. I want to be clear about that, even now. What I felt was something quieter and more final than anger, the particular stillness that comes when a structure has been tested and has held, when every post is plumb and every joint is sound and the load has found its bearing point and will not move again. In the weeks that followed, the HOA's insurance carrier came to the table with a settlement offer. The carrier had a coverage limit that fell well short of the judgment, and the board members faced the prospect of personal liability for the gap. Negotiations proceeded with a speed that contrasted sharply with the pace at which Sandra Pruitt had responded to Gerald's original certified letter. The matter resolved, under a confidential settlement agreement, at a figure Gerald described as satisfactory. The HOA's board was restructured as a condition of the settlement, with new governance documents explicitly defining the association's authority as limited to the 80 acres of Ridgeline Estates and no more. Sandra Pruitt resigned her position as board president. The county recorded a corrective plat for Ridgeline Estates, prepared by Thomas Vickers, that placed the northern boundary of the development where the 1978 Pruitt survey and the original monuments had always shown it to be. The strip of land, 36 feet, 9 inches wide, 2,847 feet long, was formally and finally confirmed as mine. I drove out to the eastern fence line on the morning after the corrective plat was recorded. The air was cool, carrying the smell of creek water and the particular mineral sharpness of caliche after a light rain. The stumps were still there. They would be there for years, perhaps decades. Old oak does not rot quickly, and these roots ran deep enough that no machine I owned could pull them cleanly. I had made peace with that. A stump is a record, in its way. It holds the ring count, the age, the history of every dry year and wet year the tree had lived through. I had arranged, through a native plant nursery 2 counties over, for a delivery of 212 bald and burlapped live oak saplings, 6 more than had been taken, because my grandfather Elias had always planted a few extra, on the theory that some would not take, and it was better to find out early. They would arrive in the spring. I would plant them along the fence line the way Elias had planted his, 30 feet apart, each one set in a hole dug to twice the width of the root ball. The creek made its sound in the distance. The limestone ridge caught the early light the way it always had, the way it had caught it on the morning my grandfather walked this land for the first time as its owner. The deed in my fireproof drawer said 340 acres. The corrective plat now confirmed every foot of it. The record was clean. When an institution with apparent authority makes a claim against you, the first question is not whether the claim feels legitimate or whether the person making it carries a clipboard and a title. The first question is whether the claim has a legal foundation. And the answer to that question is never in the institution's confidence, never in the weight of its letterhead, never in the certainty of its tone. The answer is always in the record. It is in the deed, in the survey, in the plat, in the monuments, set in the ground by the original surveyor and confirmed by every instrument that followed. The record does not argue. It does not raise its voice. It simply holds, the way old oak holds, patient and indifferent to whatever is said about it until someone finally looks. If you have a story about land or a boundary or an authority that reached further than it had any right to, leave it in the comments. I read them.